Alright, hi. Let's zoom in. Continuing part 111.3 oral hearings. Title 49, Chapter 10, November 1st, 2018 edition. 111.3.1, scheduled hearings continued, hearings. 111.3.2, subpoenas. 111.3.3, authority officers. 111.3.4, pre-hearing conferences. 111.3.5, stipulations. 111.3.6, appearance, withdrawal, absence from hearing. 111.3.7, intervention petitions. 111.3.8, written examinations, orders of procedures. 111.3.9, prepared statements. 111.3.10, records of other board proceedings. 111.3.11, abstract documents. 111.3.12, exhibits. 111.3.13, filing evidence, subsequent hearing copies. 111.3.14, objections to rulings. 111.3.15, interlocutory appeals. 111.3.16, oral or argument before hearing of officer. 111.3.17, transcript of records. 111.3.18, briefs. 111.3.19, pleadings, part of the record. 111.3.20 through 30, reserved. All right, 111.3.1. Scheduled hearings continue for the continued hearings. Assigning service for the posting of the notice for the proceeding of which an oral hearing is to be held. The board will assign the time and place for the hearing. Notice for the hearings will be posted on the board's website. Will be served upon parties and such other persons as may be entitled to receive the notice under the act, which will be available for the inspection of the board office. Requests for change assignments, requests for the postponements for the day of the hearing will be granted only in exemption circumstances. C. Continuances may be granted with the discretion of the presiding officer. If the presiding officer announces the time and the place for the continued hearing on the record and no further notice may be given. 111.3.2. Subpoenas. Issuance of the subpoena may be the issue with the direction of the board on its own motion. Upon the request, the subpoena may be issued with the board by its officer presiding with the hearing. It must be signed with the director of office proceeding with a member of the board. Request. The request for the subpoena to comply with the appearance of the person for the hearing to give the oral testimony and not to produce documents that may be made either by letter or only with the original need for the file by the board. Or orally upon the record of the hearing showing the general relevance of the responsible scope of the evidence sought to be introduced throughout the subpoena for the person may be required. A request of the subpoena with the compelled with a witness to produce the documentary evidence show that may be written by petition. The petition should specify the particular books and papers and documents desired facts expected to be proved and should show that the general relevance or reasonable scope of the evidence sought by the officer proceeding the hearing may be granted with a request for such a subpoena made orally upon the record. Service. The original subpoena should be exhibited to the person with the service that shall read to him. If he is unable to read a copy of the copy should be delivered to him, the officer for the person making the service. Return. If the service of the subpoena is made with the United States with the marshal, his or her deputy for the service should have evidence be by the return of the subpoena made by any other person. The person shall make an affidavit stating with the date of the time and the manner of the service of the return of such affidavit on and with the original subpoena in accordance with the form thereon. In this case, if the failure to make the service for the reason for the failure should be stated with the original subpoena with the written acceptance of the service of the subpoena by the person subpoena will be sufficient without other evidence to return with the original subpoena bearing the accompanied with the required return affidavit statement. Accepted service should be returned forthwith. Chief Section of the Administrator Office for the proceedings unless otherwise directed. Witness fee. The witness who is summoned with a respond with a summons is entitled to do the same fee as paid for like service with the courts of the United States. Such fee is to be made by a party as whose instances the testimony is taken with the time and the subpoena is to serve, except that when the subpoena is issued on the behalf of the United States and an officer or an agency, therefore the fees and mileage need not to be tendered at the time of the service. 111.3.3. Authority of officers. Generally, the presiding officer have the authority to regulate with the procedure for the hearing before him and his authority to take all the measures necessary proper for the efficiency of the performance of the duty assigned to him. These include the authority 1. To hold the hearings, 2. The administrative the oaths and the affirmations, 3. To grant intervention, 4. To accept the pleading, 5. To appropriate to establish special rules procedure appropriate for the effective handling of the particular proceedings, 6. To examine the witness, 7. Issue the subpoenas at the hearings, 8. 8, to dispose of the request for the discovery. 9, to hold the conference for the settlement and the simplification of the issues. 10, to rule another motions to dispose of the procedural request. 11, to make initial decisions. 12, to exclude the any of the person from the hearing with a contemptuous conduct. 13, to take any other action authorized by the Administrative Procedure Act or by the Interstate Commerce Act, the related acts. 2, the presiding officer have the authority to terminate the examination, cross-examination, repetitious, cumulative nature, to limit the directive of the examination from the material matters. 3, to limit cross-examination to disputed material facts. 4, to require that principal examination for the cross-examination may be conducted more and more with the counsels representing with similar interests proceeding with the several parties that are involved. 5, to set the reasonable schedule of the presentation witness. 6, for the set reasonable time and limit the examination, cross-examination of the witness in order to enforce the paragraph of the officer may be required with a clear statement of the record to give the nature of the testimony to be given with any of the witness. Motion disposal of the amendment of the presiding officer should have the power to decide any of the motion to dismiss the proceeding other than the motion with involved with the final determination of the merits of the proceeding. The presiding officer for the may grant with the leave of the amend any application for the complaint with the preparation of the decision by the prevailing party of the proceeding, in which for the oral hearing itself, which the officer is able to denounce the decision either on the record after the close of the taking of the testimony, the hearing of the arguments by the officer, by appropriate the notification of the parties that are closed. The hearing that may be made subject to the initial decision prepared with the party and parties in whose favor the other decides within the period specified by the officer subject for such change for the officer corresponds appropriately with the draft prepared for him. Recording media coverage of the proceeding of the officer shall have the authority to permit or to refuse permit of the recording of the hearing means by live or delayed television, radio broadcast, or use of the tape recorder or other electronic photographic equipment by any person other than the officer or official reporter. 11.3.4 pre-hearing conferences. Purpose of the upon written notice of the board and proceeding upon with the written or oral instruction of the officer party of their representative may be directed to appear on an officer specified time and place for a conference prior to or during the course of the hearing and in lieu of the personnel appearing to the submit the suggestion of the writing of the purpose of the formulating issue, the considering the simplification of the use, the necessity of the desirability of the amending of the pleadings either for the purpose of the clarification, amplification, and limitation, possibility of making the administration certain averments of the fact of the stipulation concerning with the use of any of all of the parties of the material matters of the public record, such as the annual reports of the likelihood of what unnecessary introduction of the proof, the procedure of the hearing, limitation of the number of the witnesses, the 6 of the proper priority of the prior mutual exchange between the or among the parties for the preparer of the testimony exhibits and such other matters include the disposition request of the discovery may end as they may aid simplification of the evidence disposition of the proceeding particles may request for the pre-hearing conference. Alright, B. The facts disclosed, the privileged facts disclosed in the course of the proceeding pre-hearing conference are privileged and except for the arrangement will not be used against the participating parties either before the board or elsewhere unless fully corroborated by other evidence. Recordation and decision action taken for the conference include the resuscitation of the amendments allowed by the pleading of the arguments made by the parties to any of the matter that concerning the defined issues will be recorded with the appropriate decision unless the parties are either within the written stipulation or to such matters or agree to a statement that are made by recorded by officers. Alright, our objection of the decision subsequent to the proceed with the decision is entered. Parties may, within 20 days of the day of the service which are such lesser time at the step of the officer present with the objection time on the ground, the decision does not fully or correctly embody the agreements reached for the at the conference thereafter the terms of the written stipulation statements of the officer, if the case may be, will be determined. The subsequent course of the proceedings unless provide with prevent the manifest of the injustice. 11.3.5 Stipulations. A part of the proceed with the contempt of the pre-hearing provisions of the party may stipulation with the writing filed with the board at any time of the state of the proceeding, the oral made with the hearing and the agreement upon with the pertinent facts of the proceeding with the parties should agree within the facts of the manner whenever practical. 11.3.6 Appearance, withdrawal, and the absence for the hearing. Who may appear? When any individual may appear for himself as a member of the partnership to the party and to any of the proceedings may appear with the such for the partnership to adequate identification, bona fide officer, full-time employee or corporation, association, or individual may appear for of such corporation, association, individual by a personal, provide permission of the officer presiding with it. The hearing the party may also be represented with the practitioner. Withdrawals, absence of the hearing, the petitioner will enter his appearance with the hearing shall not be permitted with the withdrawal of the hearing with the willfully be absent therefrom, except for the good cause, whenever practicable, only by the permission of the presiding officer. If a person who has entered the appearance of the withdrawal from the hearing of the manner other than specified by the board or the officer make such action in the interest of the justice for the protection of the laws right of all the parties for the receiving the circumstances of the case that may warrant, including striking out of all of the and any part of the pleading of the offending party, with include the possible dismissal of the action proceeding or any of the part or thereof the entry of the order to default against the party if the withdrawal is without permission of the presiding officer to discipline with the practitioner concerned. 11.3.7 Intervention petitions. How request an intervention will be normally granted only upon petition's exceptional circumstances for the issue would not be broadened and proceeding delay with the officer made his or her discretion allow the intervention upon the motion made orally over the hearing. Content generally. Petition leave of the intervene must set forth the grounds for the proposed intervention posted with the interest of the position with the proceeding whether the petitioner position is in the support or the proceeding by the formal complaint with the affirmative relief of the sought with the petitioner with the position should conform to the requirements of the formal complaint. When filed with the petition, leave to the intervene with the proceeding should be filed with prior to or at the time with the proceeding is called for the hearing, but not after the acceptance could a good cause shown. Broaden the issue if filing. If the petition seeking for the broadening of the issue with the show that they would not thereby unduly broaden in the respect of the therefore seek affirmative relief of the petition should be filed at the time of the permanent service upon answer by the parties in advance by of the hearings. Copy service in reply for the petition for the leave of the intervene with the tendering with the hearing of the sufficient copy of the petition must be provided with the distribution and part of the representative of the hearing with leave of the grant with the hearing 10 copy of the petition must be furnished with the use of the board when petition to leave of the intervene with the not tendered at the hearing of the original 10 copies of the petition should be submitted to the board together with a certificate of the service that has been made by the petitioner. Any reply opposition of the petitioner to leave the intervene with the not tender of the hearing must be filed within 20 days of the service of the petitioner of the intervene to intervene at the discretion of the board to leave the intervene may be granted or denied before the expiration time allowed for the reply of the disposition. Leave the intervene will be granted only with the petition with addressed the issue with the reasonable leave for the pertainance of the issues already presented and which would do not unduly broaden them and then leave the granted with the petitioner become the intervener or in the party over the proceeding. All right, 11.3.8, witness examination order of the procedure. Witnesses will be orally examined under oath before the officer for the life of the fact of the presenting with the board in the manner of the provide for the unmodified procedure for the formal complaint with the application investigation procedures, complaint with the application and the respondent, respectively, shall open and close with the hearing in the event of the for further hearing of the granted on the petitioners requesting further for the hearing shall open and close with the proceeding. Instances exits in which the parties are other than the respondents may open them and close with the investigation with the burden of proof it is not upon the respondent. Interveners shall not follow the party on which the behalf of the intervention is made, but the foregoing order of the presentation may be varied by officer. 11.3.9 Prepared statement. All right, with the approval of the officer of the witness of the read of the record as of the testimony statement itself of the fact of the expression of the or opinion. The expression of the opinion prepared by the witness or written answer for the interrogatories of the counsel. The prepared statement of the witness who is present at the hearing will receive the exhibit that provides the statement that does not include the argument before any such statement is read the admitted of the evidence that the witness shall deliver to the officer for the reporter to opposing counsel as may be directed to the officer for the copy of such statement and or of the such interrogatories written with the answer thereto and admissible with the evidence contained in such a statement that will be subject to the same rules and such testimony pursued by orally, included with the right of the cross-examination of the witness. If the officer may be required of the witness testify orally, if the officer's opinion of the memory of the demeanor of the witness may be of importance. 11.3.10 records and other proceedings. A portion of the record before the board and other proceedings that may be offered of the evidence or oral hearing and party they make such an officer must provide an exhibit of the certified copy of the materials of the introduced the hearing officer may waive the requirement of the copy of the may be provided the subject of the condition his or she may impose the assure of the copy will be available later if need no the expense of the board to assure that the interests of other parties are not prejudice any other author of the evidence under the subjection will be subject to the objection of the other parties. 11.3.11 The abstract for the documents such for the freight with the bill for the bills of landing is numerous for the officer may refuse to receive all of the documents evidence instead of admit with only a limited number of the representative documents if he may instruct if the pre-officer will be proving damage of the introduction deferred only to the opportunity to comply with the statute 11.33.2 with a pre-offer for any other purpose of the the officer may be required of the party orderly fashion to abstract the relevant data from the documents according of the party for the reasonably opportunity to explain both the documents within the abstract and thereupon on other abstract and evidence for the exhibit form. 11.3.12 exhibit the copies unless other officer otherwise direct for the original 10 copies for the exhibit. The documentary character should be furnished with it for the use of the board originally was delivered with the report or copy of the officer of the hearing is before the board with a copy of the exhibit that should be furnished for the member of the board with the board otherwise the direction unless for the officer for the cover of the direct over the otherwise reasonable number of the copies should be furnished to the counsel with the attendance for the hearing. Interchanging prior to the hearing when the ever practicable to the parties shall the interchange the copies of the pertinent material and matter before the commencement of the hearing with the board presiding officer may so the direct. When exclude the how to treat it when the exhibit if identified the direct for the two and exclude the officer will develop whenever the party offering the exhibit the withdrawal of the offer if so for the permit with the return the exhibit to him. If the excluded exhibit is not withdrawn, it shall be given the exhibit number for the identification incorporated with the record for the exhibit number once you, but the identification will not be duplicated thereafter. 11.3, 111.3.13 filing evidence and subsequence. Separate provided in the section expressly may be permitted if the paragraph the instant of the board will not receive the evidence considered as part of the record of the document, letters, and other writings submitted for the consideration in connection with any of the proceeding after close of the hearing, that may return with the documents to sender before the close of the hearing of the officer may or the request of the party with the upon of his own motion upon the agreement with the party that require that his or party of the furnish of additional documentation evidence supplement existing records for the stated period of the time of the document evidence of the further furnish of the waiver will given the exhibit the number of the time of the filing with the other parties advised accordingly unless otherwise directed by the officer of the original 10 copies submission should be filed with the board. 11.13.14 are object of the rulings. On the inspection party at the time of the ruling is made with the self of the main known with the officer on the required action with the desired officer for the take with the objection to the action with the officer with the ground with the objection not suppressed from the brief of the consideration waived will no brief where no brief is filed with the objection will be considered as waived if not pressed and appeal with the reply to an appeal then filed with a separate with the position dealing only with the objection. 11.13 11.1 3.15 interlocutory appeal. For the ruling of the presiding officer may be appealed prior to the service of the initial decision only if the ruling denies and terminates any of the person's participation. The ruling grants the request for the inspection documentation not ordinarily available to the public inspection. Ruling overruled the objection based on privilege result in which the ruling is required for the presentation of the testimony and documents. The presiding officer found that the ruling of the may result with substantial irreparable harm, substantial deterrent of the public interest, and undue prejudice to the party. 11.13.16 oral argument before hearing and of the officer for the discretion of the hearing officer for the the reasonable notice for the party for the oral argument may be with the close of the testimony before and after an alternative filing of the written briefs. Such agreement which should be included with the requested findings and conclusions will be recorded and made part of the transcript of the testimony will be available to the board of the consideration in the decision of the case of the making such arguments will not preclude oral argument before the board. 11.13.17 the transcript of the record following after the close of the hearing with the complete with the transcript of the testimony taken of the exhibit that shall be part of the record of the proceedings corrections suggestive of the corresponding of the transaction ordinarily would consider the only if offered no later than 20 days of the age of the transcript to file with the board. A copy of the letter originally only needed to be filed with the board to require requesting suggested the correction should be served upon all parties of the record within 2 copies of the official reporter, and objection of the correction parties that disagreeing with the correction with the suggestion of the pursuant paragraph B of the section should file with the Roby right, and objections to the same manner with the suggested corrections are to be filed with objections to suggested corrections should be filled with no later than 15 days after the filing with the board suggested corrections. If the no objections are timely filed with the effect offer the proceeding shall make with the suggested corrections to the transcript. If the objections are timely filed with the file officer will preside of the hearing shall be determine the merits of the suggested corrections, enter the appropriate with the decision of the proceedings. No free copy of the board will not furnish free copies of the transcript to any party any of the proceedings. 11.13.18 when filed with the proceeding of the hearing of the judge oral hearing of the brief of the file with the fact of the state of the officer for the record of the officer shall have fixed at the time of the filing briefing the simultaneously filing with the normally be required to reply with a brief that normally be permitted. Evidence of the abstract with a brief file with the after hearing with the main content of the abstract of the evidence relied upon with the party of the filing with the presented as assembled by subject of the reference of the page of the record with the written end of the exhibit that will be evident if the appears in the evidence with the party objects not to include with a separate abstract for the relief in his brief that shall give a specific reference to a portion of the record of the transcript they otherwise relied upon with the support of the respective statements of the facts made through the brief. The requested findings, each of the brief shall include the set for the request of the specific findings separate stated and numbered as the party desire of the board to make. Exhibit of reproduction. Exhibit shall not be reproduced in the brief of the may be shown within reasonable limit of the appendix to brief. The analysis such exhibits should be included with the brief where pertinent. All right, 11-13-19. Pleadings of the part of the record matters of the fact verified with the file with the prior to oral hearing. They are not specifically denied of the constitute evidence that are part of the record. A witness who would present the evidence must be made available with the cross-examination request that is reasonably made, but the rules do not apply with the protest against the tariffs or the records. All right, Part 114, Evidence Discovery.